Okay, great. Good morning.
This meeting is being recorded.
Good morning, everyone, and welcome to the August 9th Nurse-Midwifery Advisory Committee meeting. I think our moderator usually starts, right, with some information?
No, you would call to order and do the roll call to establish quorum, and then our board moderator would give general instructions for format of a teleconference meeting.
All right. So we will call this meeting to order. And do we need a roll call, or is it evidence by who's logged in that we have a quorum?
No, we do need to do a roll call to establish quorum.
Okay, so let's roll call. For a quorum, I'll start with myself. Mary Kay Phillips is here. How about Hillary Reyes?
I'm here. Hillary Reyes is here.
Ruth Milkey?
Ruth Milkey is here.
Jenna Shaw Batista? Not here? I thought she'd logged on. No?
She is not in the list of participants at this moment.
Okay. James Byrne?
Good morning. Present.
Good morning. Misa Perrone-Burdick?
Present.
And Rebecca DeSantis?
Present.
Good morning. So all but Jenna for the members. So we do have a quorum.
Excuse me, this is Reza, legal counsel. It looks like Jenna is in the list of attendees. So
I thought I saw that.
Yeah, maybe moderator, could you see if
maybe she needs to be let in?
Fully logged in yet.
Well, she's here.
Yeah, she's here. She's not fully logged in yet. She doesn't have camera or speakers yet.
Okay.
Yeah, she just barely joined on refresh.
Okay. Do you want to wait, give it just a minute?
No, we can go ahead and give formal instructions while she continues to log in.
Okay, that would be great. Thank you.
Janet, can you try?
Sorry, that just now finally downloaded. Can you hear me?
Yes.
Yeah, the website's a little different this morning. Okay, want to go forward with the moderator information, general instructions?
Good morning. This is the BRN moderator. I will be moderating the meeting. To facilitate public comment, we will be utilizing the WebEx question and answer feature. When the committee reaches a point in the agenda at which public comment is appropriate, the question and answer feature will be turned on, and members of the public can indicate that they would like to make a comment by inserting the phrase, "I would like to make a comment," in the question box, which is typically in the lower right of your screen. I will then call on the individual and unmute their microphone. The individual will have 2 minutes to make their comments. I will not give a warning as your time approaches. I will mute your microphone and will announce that your time has exceeded the time allotted. I will then move on to the next member of the public who has a comment. Please note that the question and answer feature is being used only as a means for members of the public to represent that they would like to make a verbal comment. This is not a means to ask questions of the moderator or members of the committee. Such inquiries submitted using this feature will not be answered. When asking a question, please make sure the question is directed at the host, me, in the dropdown. I will provide a brief reminder of this approach at the start of each public comment item. Finally, when committee staff or senior staff are not speaking, I would like to remind them to mute their microphones. If I detect background noise during the meeting as a result of unmuted microphones, I will mute your microphone. Thank you.
Thank you. We'll move on to item number 3, public comments for items not on the agenda and items for future agendas.
We will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, I would like to make a comment. Committee Chair Phillips, there are no public requests for comments. Would you like me to close this window?
Yes, please. All right, moving on to agenda item 4, review and vote on whether to approve previous meetings minutes. Have all the members had a chance to review the minutes?
Yes.
Yes.
I would just like to make one comment. Paris Maloof-Burry had recommended that we make an agenda item for this meeting regarding delays in the licensing process. We didn't exactly make an agenda item regarding that process, but we do have an agenda item, item 10, where we're going to discuss the enhancements and efficiencies that have been made in the licensing program. And a lot is going on to change and improve this process at the BRN. So we will talk about it at this meeting, and then maybe we can agree or disagree whether or not we need to have a future agenda item on that issue. Would you agree, Lori?
Yes, I think that the licensing update will answer a lot of questions, and that is absolutely the forum that we can ask further questions and further discuss as well.
Okay, thank you. Would any of the members like to propose that we accept the meetings or the previous meetings minutes?
Move to propose.
A second.
Okay, so we have a second.
This is Reza. So I believe that was James that made the motion. Is that right?
Yes.
And who made the second?
I think it was Rebecca.
Was.
Okay. In general, if you would just state your name when you make a motion for our note takers, please. Thank you.
Thanks. Duly noted.
All right, so we approve the previous meetings minutes.
So we would need to, on that one, take a public comment and then a quick vote.
That's fine. So we'll move to public comment regarding the approval of previous meetings minutes.
We will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, I would like to make a comment. Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, I would like to make a comment. Committee Chair Phillips, there are no public requests for comment. Would you like me to close this window?
Yes, please. So now can we say that we have approved the previous meetings minutes?
We need to do a roll call vote.
Okay. So let's do a roll call. I'll start with myself, Mary Kay Phillips. I approve or agree.
Hillary Reyes, agree.
Ruth Milky, agree.
Misa Perrin Burdick, agree.
James Byrne, agree.
Jenna Shabatista, agree.
Rebecca DeSantis, agree.
All right, we have a total agreement, so we have approved the previous meeting's minutes. Let's move on to agenda number 5, discussion and possible action regarding meeting dates for 2023. I hope that everyone's had a chance to review this information in the packet. I'll let Lori explain some of the changes that are occurring for 2023 and how or why we've moved to just 2 meetings per year and kind of what that means for the committee. Can you talk to us, Lori?
Yes, I can.
Thank you.
We did last year when the NMAC committee was started, same as when the MPAC committee was started, you guys had the onus to implement legislation that was just passed. And so we did increase the amount of meetings and the lengths of meetings. And additionally, with the NPAC committee, we held subcommittees. So now that the majority of the legislation that was needing to be implemented has been completed, and we're now voting on next year's agenda, we plan to go back to the normal 2 meeting a year advisory committee agenda, advisory committee scheduling. So we do have 4 advisory committees at the BRN. One is the APRN. The next one is the NEWAC or NEWAC. And then, of course, NPAC and NMAC. And so those will be alternated. The NPAC and NMAC will be held in the same months, on the same days, I believe, is kind of our goal, but we could separate them. And we're putting that forward for a vote. If there does become a time where there is more information that needs to be dealt with at an advisory committee level, then you would agendaize a request to add an additional meeting. However, the plan really is that if there is a lot of work that needs to be completed, and we know that there is cleanup on the website and such that still needs to occur, that those can be managed within subcommittees. The plan for subcommittees is that 2 people form a subcommittee. They do not have to publicly notice a meeting. They do not have to hold to a strict schedule. And a lot of work can be done between those 2 people. And then as we do in our board meeting, we have board committees, and that is where the majority of the week work is done. And then at the board meeting, it is essentially a report out and a final vote. And so the intent is to have these subcommittees perform the work, get a lot of items kind of moving, and then come together at the advisory committee meeting that is publicly noticed and report out that work and share what is being done and get public comment and feedback, make adjustments as needed based on the public comment and feedback, and then move forward and continue the work. That way, we are not limited to just 3 or 4 meetings like we were last year, and now 2 meetings this upcoming year for work to be done. That also expedites the meeting itself, so that we are not here for hours and hours kind of speaking on a single topic. We're able to bring the information forward, have a discussion based on the materials that have been submitted and reviewed by everybody, and then action done so that the recommendations of the NMAC can be forwarded on to the board for implementation or review. So I hope that kind of cleared that up. We do have the meeting months in the agenda for you guys to view. And if those months are okay, we can make a motion to accept the months, and we can work with your liaison to set dates if that's easier. Or if you guys believe that you guys can set some dates during this meeting, we would be very happy to have a discussion about proposed dates in March and September that you think would be best for the NMAC to meet, including time frames, so that we can get that scheduled and presented to the board in November to be ratified.
I have a question. The subcommittees that the 2-person subcommittees or working groups on issues, do those need to be identified and approved by the committee at one of these meetings, or can they be developed and be working together in between meetings? Do they have to be identified and approved at a meeting before they can begin any work?
Not necessarily. So there cannot be communication, of course, outside of this, but by the members of the advisory committee in a group to come to an agreement. But if people have specific passions or focus that they would like to work on, that can be communicated through the liaison. So currently, most of your meeting agendas, the materials, your calendar, et cetera, coordinating all this happens through the Chief of Licensing, Macaulay P. Sarens. And so she could send out a email notification to everybody, and people can say, hey, this is what I would like to do. And then we can put that out to the group and be the person that kind of manages that initial setup. However, if there's something specific right now that you would like to make sure that was on the table and set up, I know that you, Mary Kay, have been kind of talking about a strategic plan of some sort for the NMAC committee. And that's absolutely something that could be done, but it doesn't have to be as formal as that. There are several times that I'm sure 1 or 2 of you guys get together and have a conversation, and that's perfectly fine. And that can continue to occur. When you are meeting with that person, you can always request to have me attend. You can have Reza, our legal counsel, attend. And those end up being some pretty good working groups to get input, to get feedback, and not have to kind of go back and forth and wait for a noticed meeting to get done. However, all of this information that is done is reported out in a public forum. It is put onto the table for the public to have input through public comment. So it is not something that is kept secret or done behind anybody's back. It is absolutely brought forward. It just allows for the work to continue and the work to be done without having to wait months in between to get that completed.
Can I ask a question? This is Ruth Milky. Hi, everyone. On that note, is there a protocol for, I don't want to say inviting, but using outside consultants? I mean, I'm thinking specifically like this committee needs to access one of our policy people in CNMA or something like that. Are they allowed to be invited to that subcommittee meeting, or tell us about that?
So you're allowed as an individual to work with whoever you choose to work with, to have conversations, to get feedback, to have them actually come into a meeting that I would have to really defer to Reza on that. I don't know that that is something that is commonly happening because of the different focuses between the BRN and advocacy groups. The various advocacy groups are there for the promotion of the public, and they manage, promotion of the profession. And they manage a multitude of issues, including issues that are not BRN specific, that fall, within the purview of CDPH or fall within the purview of DHHS or CMS, and is not BRN specific. And so with that kind of understanding and the BRN's focus of being strictly just for the protection of the public, it doesn't always align, which is why it is absolutely okay for you guys to have those one-on-ones, to go back and seek feedback, guidance, any kind of information seeking that you have that you then use to contribute and have discussions and bring that information forward. But I will actually let Reza kind of opine on whether or not an advocacy group of some sort can join on a routine basis those subcommittee work groups. My thought off the top of my head is no, but I will leave that up to a legal consideration.
Thanks, Lori. So I'll back up and just respond for add on to what Lori was saying first, to the piece about kind of creating a subcommittee within one of these public meetings versus outside of a public meeting. I don't disagree with what Lori said. I think in general, to the extent that this committee knows of an issue that it wants to refer to a subcommittee, it's always nice when it's done publicly within one of these meetings. So, and we've done that. So following that similar model would kind of be the preferred approach, where, like we did with the website, we within a meeting identified an issue, identified two members of the committee who were willing to take that on outside of public meeting as a subcommittee and look into that. So in general, when you can, I think that would probably be my suggestion, to take that route. But if an issue, let's say between two meetings, comes to mind and it's something that maybe it's time sensitive, or maybe just for whatever reason you want to take that up without waiting for the next public meeting to establish a subcommittee and then wait for the subcommittee to go on and do the work and then bring it back at another subsequent public meeting. If in between meetings you want to form a subcommittee, I think that can be done as well. I think probably to be on the safe side, keep the committee liaison apprised, just so so that we make sure that there are no mistakes, because I think this is all deriving from the Bagley-Keene Open Meeting Act, these restrictions and limitations and things, which if you're not well versed in it, or very just kind of used to operating that way, it's not necessarily a natural way of conducting business. So so it's easy to kind of slip up and inadvertently violate that act. So some of the violations, well, really the main type of violation that can occur in that situation is, I'll cite to Government Code 11-121. That's where the Bagley-Keene Act defines a state body which is subject to all the rules and limitations that come with having public meetings. So a two-person subcommittee can discuss outside of a public meeting something that's within the jurisdiction of the NMAC. When you go beyond two members of the committee is where we run into a problem. So if you have, let's say, in between two public meetings, a committee member decides this is a really pressing issue, we should jump right on this, and reaches out to the committee liaison and says, hey, I'd like for us to have a subcommittee look at this before the next formal meeting. we can coordinate a two-person subcommittee. That subcommittee can discuss amongst itself, amongst the two people, the issue freely without needing to notice a meeting and invite the public and all that. Where we might run into a problem, though, is if that subcommittee, sends an email out to the rest of the committee and says, here's what we've been discussing, and here's kind of where we sit on this issue as of right now. Because then you would have gone beyond a two-person subcommittee, and the discussion would now be amongst 3 or more, or maybe the entire committee, and that's a problem. So the Bagley-Keene Act defines a state body to include various things, A, B, C, D, E, in that government code section that I cited. One of those subdivisions includes, as a, quote, state body, an advisory committee created by formal action of the state body that consists of 3 or more persons. I paraphrased a little bit there, but so for this issue, the key there is 3 or more persons. So, and the idea, for the benefit of our public, I'll say this: the idea is not to exclude the public from any discussions or conversations happening. The idea is to kind of balance having all that done in the public light on the one hand versus on the other hand, actually being able to meaningfully research an issue and discuss it offline and bring back to the public and the full committee something that's kind of a little more thoroughly researched. Because it's as Lori was saying earlier, it's a little hard within this format to research an issue and have the kind of discussions that sometimes need to take place offline over a longer period of time. So hopefully that helps. Again, the main point is we can do that. I think, again, to avoid inadvertent slip-ups, probably best to keep the staff liaison apprised, who will consult with Lori and me as needed. And of course, you can always have a direct line to me as well. So that can be done.
Thank you. Reza, can I ask, or I'd like to ask a question of the committee in general. When I first heard about this or discovered this, it was my thought that maybe as a committee, we should create subcommittees ahead of the game that had kind of a general title, like a subcommittee for cleaning up the website, or a subcommittee for licensing issues, or a subcommittee for any of our agenda items moving forward, or a really large umbrella subcommittee that would address certain issues. I can't even think of really good examples right now, but my thought was identifying these 2 people subgroups from the committee in advance, so that when issues came up that were maybe in between these meetings that are going to be pretty far apart, I wasn't in a position where I'm like trying to reach out, like, hey, are there 2 people that would like to work on this issue? That maybe there were already 2 people identified that in general, this issue would apply to their subcommittee group. What does the committee think about creating maybe 3 or 4 subcommittees in advance that maybe don't have any work on their plate right at this moment, but could potentially have work on their plate, and they're already identified as the 2 people who would be committed to that problem or issue or research or information? Any comment from the committee members?
Real quick, I'll just interject. This is Reza again. Committee members, can respond to that. I just want to mention it's not a topic that's on our agenda, the formation of subcommittees, and I was taking a quick look to see if we can kind of tie it to an agenda item that we have, which I don't really see one, but I think we can discuss it here and now, and if there is an interest in doing that, put that on the next subcommittee meeting agenda. So now we can establish whether there's an interest in doing that. And if there is, at the next meeting, we can kind of go a little more in depth and establish what those general areas ought to be and who wants to be assigned to which ones and all of that.
Okay. That would be great, and I no problem with that. And maybe the committee members aren't interested in that at all, and that would end the topic right now, that we would just create subcommittees when issues arrive. But if it needs to be an agenda item for the next meeting, and we could brainstorm about it a little bit, I definitely would put it on as an agenda item for the next meeting.
This is Jenna. I think that's a great idea for efficiency. I would support putting it on the agenda.
So are we formatting this as a motion to put on as a formal agenda item? Because if it so, I'll move to approve.
No, that would not be the motion for this agenda item. That is just a request that went to board staff, and we will make sure to get that on the agenda. The motion that does need to occur is whether or not we accept the schedule for the 2 meetings for next year. And so currently there are 2 months that are chosen, and you guys can make a motion to accept the advisory committee meetings to occur in those months and work with the board liaison to establish dates where we can get a quorum. That would be probably the easiest motion to do today. Or if you do want to discuss this further, we could discuss possible dates within that month, or you can specify that you would like to consider early in the month or later in the month, etc. But as we kind of come to discover over the last year of arranging these meetings and getting them all taken care of, that it is difficult to establish a quorum and work around everybody's schedule. So a lot of times that is left up to the board's liaison to kind of to schedule that out, but completely up to you guys if you guys think you can get that completed.
I would like to, as a group, confirm these months and even confirm a date. Now, I know we try to align NPAC on the same day, and they haven't met yet today. Is that correct? So if we propose actual dates in the month, if we agree on March and September and propose like an actual day in March and September, then will you take that to NPAC and see if like those dates work for them as well? Is that what we would do, or would we solidify those dates for us now?
Again, that's completely up to you guys what you want to do with this motion. I do just want to call just a notice to time. We are in Agenda 5.0. We are 35 minutes into the meeting, and we do have 4 more
agenda items.
More agenda items that do need to be discussed. And so I just want to make sure that we're handling this the most efficient as possible.
Right. Well, I will propose that we accept the months of March and September as our committee meeting timeframes for 2023. I'll propose that we accept those 2 months. And then I will even propose that we accept March 7th and March 12th being the second Tuesdays in those months as the potential dates. Any discussion? Or second, I guess.
This is James, second.
Okay, Mary Kim, then we would take it out to public comment at this point.
Okay, so public comment regarding the acceptance of March 7th and September 12th, 2023 for the future NMAC meetings.
We will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Committee Chair Phillips, there are no public requests for comment. Would you like me to close this window?
Yes, please. Okay, can we
take a roll call vote?
Okay. I'll start. Mary Kay Phillips, I approve.
Hillary Reyes, agree.
Ruth Milky, agree.
Misa Perrin Burdick, agree.
James Byrne, approved.
Jenna Shabatista, agree.
Get DeSantis, agree.
I think that's everyone.
This is Reza. Can I jump in here real quick? So, a couple things. First of all, it sounded like the proposal for a future meeting agenda item about creating these subcommittees, there was at least some support for that, and I didn't hear any opposition to that. So I take it that's proposed for a future agenda.
Yes.
The other thing, there was a question asked earlier that I wanted to just real briefly circle back to and touch on, and that was the question about inviting some outside person, say somebody from the professional association or somewhere else, to provide input outside of a meeting during, say, these subcommittee meetings. The government code section that I referenced, that talked about 2 members of the subcommittee. So that would refer to, the 2 members of this committee who are assigned to a subcommittee. Those individuals can absolutely consult with anyone that may be able to provide input in our professional associations. Just as one example, they're regular stakeholders, and they often have very valuable insight and input to provide. Of course, it's not limited to them, obviously. And anyone that you feel could provide some valuable insight or information or any add any value to your discussions in subcommittees is fine. I think what Lori was saying is an important thing to just bear in mind, though, that for one thing, if we're just looking at the professional associations, not to pick on them, but they do have kind of a different agenda, in a sense that they often are aligned with the BRN's agenda, which is public protection, but at times they may have kind of a different agenda, which is first and foremost for them, advancement of the profession. Again, advancement of the profession may at times align with public protection, but at times it's arguably not. So just keep in mind that distinction. You as members of this committee are advancing the mission of the BRN, which is public protection. So one thing that's important to keep in mind is that distinction, as well as just the appearance of kind of, for lack of a better phrase, kind of doing the bidding of one group or another, one stakeholder group or another. If, for example, you have a 2-member subcommittee formed from 2 members of this committee and regularly invite a specific professional association, they're there every time you're talking, it could be perceived as that association having some greater influence on the discussion than perhaps ought to. I don't want to discourage any discussions. You know, again, any valuable feedback and input, regardless of who it's from, is always great. But we just don't want to create an appearance that that this committee is kind of being steered by one stakeholder group more than any other. And of course, worse than the actual appearance is actually allowing that to happen. So bear that in mind. But you are absolutely able to consult and receive information and all that. Again, keeping in mind the restrictions I mentioned earlier. Keep it within your subcommittee until it's brought forward in a public meeting. In other words, for example, you wouldn't have a discussion in subcommittee and receive input from stakeholders outside of a public meeting and then send an email out to all NMAC members saying, here's where we're at with this issue. That discussion that goes beyond the two committee members needs to take place in a noticed meeting before the public and all of that. So just wanted to make sure that point was, I came back to that, and that's all I had. So.
Okay, thank you, Rez. I appreciate it. We'll try to approve this agenda item and move on. So we've been out to public comment, we've voted, and we have a consensus, and our dates are good, and we'll have an agenda item at the next meeting regarding subcommittees. Okay. Item 6, discussion and possible action regarding NMAC members' terms of office as specified in the updated NMAC charter. If you guys remember, we had a red-lined item in our last meeting packet that was a little bit of surprise to me, as well as everybody else, I think, regarding the terms of office as specified in the NMAC charter. So we need to discuss that and make a decision about each member's term. Is that correct, Lori? We're going to actually agree on who's got what term length at this meeting.
That would be the best path forward at this point. So with experience becomes knowledge, and when I took the position as EO, we were given a couple advisory groups that were already established. And shortly after that occurred, we noticed that the majority of the members term out at the exact same time. And so what essentially would occur within that advisory group is they started in 2017, 2018, they served their terms, and then everybody has to be reappointed as a whole to establish essentially a new advisory committee. And so we looked to guidance on how to not have that occur to the advisory committees that are being either reestablished or newly established. So we took our lead from our business profession code that was used when we had our board Sunrise, whatever you want to call it, I'm sorry. And they did a staggering of the very first term, and then all subsequent terms were identical. And that way, nobody termed out at the same exact time, essentially. And it did not cause for a new committee to be recreated on a routine basis when the entirety of the committee termed out. So we aligned all of the advisory committees with this onboarding term process. So NMAC, NPAC, NEWAC, and APRN have all been established identically. The charters have all been aligned, and the term membership time limit for the initial and the subsequent term limits are all identical. So following that guidance in the charter, there is a membership section where it talks about 4 qualified nurse midwives, 2 qualified physician services, surgeons, and 1 public member. And then immediately following that, it says, except as provided below, all appointments shall be for a term of 4 years, and vacancies shall be filled for the unexpired term. No person shall serve more than 2 consecutive terms. So the initial appointment shall be in the following terms. 2 of the 4 nurse midwives shall serve a term of 4 years. 1 midwife shall serve a term of 3 years, and 1 shall serve a term of 2 years. That is for the initial term. You can obviously reappoint for your following term of 4 years if that is what you choose to do. But the initial term will be terminated with 2 at 4 years, 1 at 3 years, and 1 at 2 years, still allowing you to continue to your second term of 4 years. Additionally, with the physician service surgeons, there's 2 of them. So 1 would have a term of 3 years and 1 would have the term of 4 years, again, allowing you guys to fill the second term if that's something that you wish to do. And the public member, because there is 1, would continue on a 4-year basis and then could reappoint for the second year. And so this is identical to the way that our board members were set up back 10 years ago. And this is how we would go forward. So we felt that with talking with Mary Kay and such, that it would be best if there were volunteers, if there was 2 nurse midwives that said, I definitely want to be here for 4 years with a possibility going for another 4 years. So that'd be a full 8-year commitment. And 1 that said, I definitely want to do 3 years with a possibility of 4. So that's up to a 7-year commitment. And 1 that says, I'm totally okay with doing 2 years and then possibility of another 4, being that it would be 6 potential years for a commitment. And so that is something that we would like to put out, and we would take volunteers. Understand that at any point, you are not held captive here for an 8-year, a 7-year, or a 6-year term, but we do love to have consistency and people becoming more versed in how to manage meetings, set schedules and agendas, and get materials and work with the board and kind of just really move these advisory committees along. And that happens with experience. And so we would love to open it up for conversation and see what you guys want to do, knowing that you could resign if, come 7 years in, you can't make that 8th year. You just let us know, etc.
I'd like to start with addressing maybe the easiest question, and that is, does our public member agree to stay for 4 years?
I do.
Okay. So that one's taken care of.
Woohoo!
Our 2 physicians. Misa, you had a question about your membership or position on the committee.
Yes. So surprising to me and my family, we have left the state of California as of 2 weeks ago, and I maintain a position, an academic volunteer faculty position in the state of California, and I'll be maintaining my medical license in the state of California. So I guess I'm curious to know what the best move forward is, given that, I still have a lot of contacts in California and I'll be working occasionally there, but I don't know that I can be the best representative advisory member.
Yeah, so I could appoint on that for a second. We do require that you be licensed in California. You are. We do require you to be working in California, and you are. There is not a requirement on your primary place of residence. Therefore, if you did choose to continue to serve in this advisory committee, you could. Currently, our meetings are held remote, and that would allow for this to continue without any interruption. When we did go back to in-person, saying next year when the Bagley-Keene provision expires on July 1st, if no new legislation has been passed at that point, we would have to go back to in-person. With it being 2 meetings a year, that could be something that you would consider coming to Sacramento and attending. We would most likely have the first meeting done and completed, and there would be 1 additional meeting scheduled for the end of the year, that if we did not have the provisions of the Bagley-Keene Act to stay remote, that you could travel into Sacramento for that 1 meeting a year at that point. However, if at any point you did think that this would not be something that you could maintain and you couldn't give it the focus and kind of attention and work that it requires, it would be best to have that conversation and look to resign your position. And we would at that point reach out and do a recruitment for a new for a new CNM or a new physician or a new public member, whoever decides that they need to leave the board. And then we would backfill that position. And so completely flexible with any of this. And Misa, you can stay. If you choose, you could stay and say that you plan to not be here for the 2023 meetings, and you would resign, with a specific date, or you could attempt to continue on this position as long as you are licensed and practicing in California. That is the only requirement, and you can absolutely maintain. So that would be up to you.
Thank you for that additional information. I think, so is there, and this is applicable to anybody who may feel that they need to step down from this committee, but is there a way to step down from the committee and recruit at the same time in a way that does not jeopardize quorum?
So quorum is just a majority. So 1 person leaving should not affect quorum because we should still have a majority. If you're looking at the continuation of the position, and there was somebody that you thought would be amazing to fill your role, you could actually share this information. You can share the recruitment. We would send it out publicly to various stakeholders. What typically is done if it's a nurse midwife position, we do advertise to all of the licensed nurse midwife within California. If it is a physician surgeon, we contact the med board and have them advertise out or provide us with an emailing list of some sort to get that message out. And what you then would at that point would take that message and deliver it to the person that you were interested in to ensure that they apply. When all the application time period closes and anybody has submitted the application, it does go through the same review process and there is no preferential treatment that is done. But at least you would ensure that that person has put their name in. There are a lot of times where if we do not do that individual communication out and you believe that that person is perfect for this position, they might not even be aware that that position is becoming vacant or available or how to even apply. So that additional kind of hand-holding by you to say, hey, the board is going to advertise, please check the email. this is the way to do it, at least ensures that person is in the kind of pool for consideration. And that's the extent that can be done. We cannot do any kind of priority or anything at that point.
This is Reza. I think if your concern is, just making sure that the committee has full roster and that we need 5 of 7. It's a 7-member committee, so as Lori said, a majority is a quorum, so we need 5. And if you're concerned, which I would appreciate, of course, ensuring that the committee doesn't kind of drop below that minimum of 5. Because if we have 6, then 2 people not being able to make it for some reason would impact quorum. If that's your concern, and again, grateful that you keep that in mind, you could, I suppose, indicate that you could perhaps ask Lori how long it might take to do a recruitment and indicate that you intend to resign as of an effective date, and therefore stay on until that time to kind of help with the quorum until then. And then hopefully by then the recruitment will have gotten far along enough that shortly after that we would have your vacant position filled. So that's another option to just indicate your intent to resign as of a future date that would allow some time for that recruitment.
Okay. Thank you, Reza. I was using the term quorum to refer to the minimum number of members that are required for a vote. And I also wasn't sure if there were a minimum number of certain type, right? So, if 2 physicians are gone, can the committee move forward? If, you know what I mean? If the, that's because other committees I sit on require a certain number, other interdisciplinary committees require a certain number of each discipline. But it doesn't sound like that's the case here.
Correct. That's a good question. Good point. We need 5 members of any composition, whether they're CNMs, physicians, public, any composition that adds up to 5 or more.
Thank you.
Lisa, for the purpose of this meeting today and this agenda item, are you willing to accept the 3-year position as the physician identified for 3 years, knowing that if you need to resign, you would go through the appropriate steps to resign?
I don't really know what that means, accepting, but then being able to resign. I think I haven't decided my commitment moving forward yet. I'm in the state of Idaho, as many of you know. There's a lot going on here. And so I don't have an answer yet.
I think, Lisa, it would be beneficial to assign your position, not you specifically, but your position to the shorter term limit, knowing that you've already served a year of that. And so that way, when we do backfill your position when you do resign, then that's the position that would carry forward. And then what we can do is, as long as the other physician member is not dealing with these competing priorities, that that second physician member would take the longer term. And I think that would be the easiest thing to move forward. And that way, when you say you're not tied to this, it's the position that you feel is tied to the shorter term limit.
Great, thank you. Then yes, I accept.
And James, do you have comment?
Yeah, I'm really flexible. So I'm totally available to continue for the 4-year term and would have been willing to do the 3-year term. Just based on the overall discussion, sounds like the proposal for my position to be the 4-year and the other to be the 3-year, that could make sense.
That would be great. Thank you.
Okay, awesome. Okay, now for the midwives. I'm not sure how you guys want to approach this. Does anyone want to jump in with a request or a comment?
This is Jenna. I have a comment. I'm super flexible. I'm happy to do whatever anyone else wants. And that includes the longer term, since I live in the Sacramento Valley and it would be easy for me.
I think I agree with you. I think that's awesome. And I think that you should fill one of the 4-year positions if you're willing. Okay?
Sure.
All right. Ruth, what's your feeling?
I do not live up in Northern California like Jenna, but I have a son and daughter-in-law who live in Sacramento. So, I mean, and I have I know this shouldn't be a personal reason, but I have privileges at 2 different hospitals that are both trying to figure out how to apply SB 1237 in allowing midwives to have independent admission privileges. So I have a personal reason for being willing to be on the longer term if that would be the pleasure of the committee or something of interest.
Okay. Let's see, Hillary.
Yeah, this is Hillary. I think that I'm leaning more toward a shorter term. I've actually already been in the former iteration of the NMAC for 4 years, so I think I may prefer to transition at some point in the future, but I'm open to whatever is needed.
So if you took the 2-year term, my understanding from Lori is that would be renewable.
Yes.
So if you want to just commit to the 2-year term now, knowing that at the end of that 2 years, you wanted to apply for it again.
Yeah.
Okay.
That would be fine.
Okay. And then that would put me in the 3 years. And
Yes,
I'm flexible. How does everyone else feel about this scenario?
Okay, so I will repeat off the term limits if that's helpful. Jenna and Ruth would take 4 years. Mary Kay, you would do 3, and Hillary 2. Misa's position would be 3, James would be 4, and Rebecca would be 4.
So
and if you wanted to make a motion to accept that and get a second, we can go out to public comment.
Can we clarify those years? So I know we start, so from our start date, which was 2021, correct?
We could do that. We could send that out into an email for everybody, and we'll put it on our website as well. There is a section, if you go into our website, about the board. It talks about advisory committees, and everybody is listed there, what position they fill on the advisory committee, and the term dates would be listed there as well.
Yeah, so that we're not just saying 4 years, we actually have a date.
Correct. Yeah, we will have those dates and we'll put it on our website.
Okay. So does this need to go out for public comment?
We need a motion to accept and a second, and then go out to public comment.
Okay, I'll make a motion to accept the positions as we just read off, that Lori just clarified. I'll make a motion to accept.
A second. Byrne, second.
Thank you. We'll go out to public comment now.
Out to public comment.
We will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Committee Chair Phillips, there are no public requests for comments. Would you like me to close this window?
Yes, please. Okay. So let's take a vote. I'll start. Yes, I agree with the motion. Mary Kay
Hillary,
Phillips.
Hillary Reyes, agree.
Jennifer Batista, agree.
Byrne, agree.
Misa Perrin Burdick, agree.
Becca DeSantis, agree.
Did we get Ruth?
Ruth, are you able to unmute and vote? There is a majority of vote on the table, so you could accept this and we can move to the next agenda item.
Okay,
And
let's for time purposes, let's just accept it and move on. Thanks.
Thank you.
All right, and that was easier than I thought it would be. So thank you, everyone.
Reza, were you trying to speak?
Just for whoever's taking the minutes, they'll want to log the votes. So we can move on, but Ruth, if you could work on your microphone so you can record your vote on this particular item. It's strange, she was muted earlier.
Yeah, it's still showing her as a panelist, but we will have board staff reach out and see if we can troubleshoot with her.
All right, thank you. Agenda item 7, discussion and possible action regarding updates on regulatory changes to California 7.0 Code of Regulations, Title 16, Section 1463, Subdivision E.
Thank you. So when looking at SB 1237, the majority of everything was completed and in the Business Profession Code, and the committee made the recommendation to simply just update an FAQ and provide some additional guidance to help the stakeholders and the public to transition with those updated changes. One thing that was noted on review of the California Code of Regulations that is within our Nurse Practice Act is 1463, where it talks about scope of practice. A, B, C, D are still absolutely appropriate. However, E may be needing some updates. And so what E previously said was other practices and procedures may be included when the nurse midwife and the supervising physician deem appropriate by using the standardized procedures as specified in Section 2725 of the code. As you guys know, that you guys do not have a specific supervising physician anymore, and rarely, if at all, utilize any standardized procedures. So the suggested language to update would be the provisions of patient care that fall outside the independent scope of services specified in Subdivision A in Section 2746.5 of the code under mutually agreed upon policies and protocols that delineate the parameters for consultation, collaboration, referral, and transfer of patient care signed by both a certified nurse midwife and a physician. If you guys agree with that language will be put forward to our regulatory attorneys for review. Any suggested updates from them would then go forward to the board, and the board would then need to vote and make a motion to move forward with the regulatory process to update this. If there's something in Section E that stands out to you as being completely not acceptable, please let us know and we'll make some amendments to it at this time. However, if there is none and there's no real discussion, you guys could make a vote to accept the language as written, and we will put that out to our regulatory attorney so that they can wordsmith it and get it to our board for vote so we can move this along.
Sorry, that was a naughty kitty.
Was there any questions around this? Did somebody want to make a motion to accept, or did they have any proposed edits?
I, Rebecca, move to accept.
Thank you. And do we have a second?
I'll
Hillary.
second. Oh, I'm sorry.
Okay. That's fine. Hillary or Mary, accept the second.
Hillary, that's fine. We will take you down in the notes as a second. And then Mary Kay, do you want to open us up for a public comment, please?
Yes, let's move to public comment regarding agenda item 7.
We will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in the request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Committee Chair Phillips, there are no public requests for comment. Would you like me to close this window?
Yes, please. Okay, let's take this item to a vote. I'll start. Mary Kay Phillips, I agree, accept.
Misa Perrin Burdick, accept.
Hillary Reyes, accept.
Jenna Shaw Batista, accept.
Rebecca DeSantis, accept.
James, are you going to vote?
I'm not sure if we're having like some connection or audio issues at all.
Can
Again,
they type in a vote if they're able to.
we will have board staff reach out and see if there's any issues or something with this. We did get a majority vote, is that correct?
We're missing James and Ruth.
Ruth was not able to come back on. Let me look. Ruth is in the list of attendees. Board moderator, can you elevate her, please? And then I'm thinking this might be kind of the same process that James might have to do, is he may have to log off and reconnect.
Okay.
I think there are connectivity issues because my screen just froze for a long time and I wasn't able to unmute.
Okay. Ruth is on now, so we could get her vote.
I approve. This is Ruth Milkey.
Thank you. So we do have a majority vote, and we will have board staff reach out to Dr. Byrne and get him up and going, and we can go ahead and move to the next agenda item if you choose to.
I think we should.
Yes, thank you.
Okay.
This is Reza. Ruth, just for the record, for the previous agenda item regarding the term lengths, can we have our note taker record you as a yes vote on that motion?
This is Ruth Milkey. Yes, that was probably just when I got kicked off. Yes.
Okay, thank you very much. Moving on to agenda item number 8, discussion and possible action regarding updated introduction to the FAQ document regarding Senate Bill 1237. As everyone is aware, we've been working on our FAQs, and I'm just very proud of and happy that we've put together what we have. The addition that we need to look at this meeting is an introductory statement. We talked about this previously, that we thought maybe we needed a little introduction or some sort of introduction before we jump into the FAQs on the website. In your materials packet, this is here. It's in red. I don't think that I need to read it unless someone wants me to, but we need to agree or disagree regarding the acceptance of this introduction. Any comment from the panel?
Just for further clarification, this is Lori. It is stated on there in explaining the legislative intent behind SB 1237. The legislature made the following observations, and that is a direct kind of quote from SB 1237. So it is not random or just been placed on a whim. So it does have a origin that has been accepted and is part of our law.
Yes, no, none of us created this narrative independently of the legislation. The only comment that I would add is I was curious, and this hit me later, that I was curious whether we needed to say anything about the fact that there are no regulations currently or maybe to follow or at this point in time or anything like that in the event that anyone's coming to this page, or as I've dealt with in the past where people are waiting for regulations regarding our bill.
I don't know that I would phrase it necessarily as saying there's no regulations, because we do have a full article in the California Code of Regulations, Title 16, that deal with nurse midwives. And in fact, we're updating the previous regulation.
Right, I don't mean
on the passing of that. So I don't know that we can make a specific statement.
Like no regulations.
But when we do update the website, we could make a statement on the website that says if you're looking for regulations around implementation of SB 1237, and we could link them to the proposed regulation update that would be the one that we just voted on in the previous agenda item. We would have the FAQs here as well. So we can do a lot within our website update to do that. I know that you guys are still waiting on that. There is a lot to be managed on that website update, and we will be getting something on that soon is our intent. That's something that at least shows that we're making progress on that. But in this agenda item here, if you guys are okay with the red added language, we could take a vote and have it accepted and get a second and then go out to public comment. If there are any further questions or I hear you, Mary Kay, on that update, we can definitely do that outside of an FAQ. It's not.
Okay. No, that answers my
question. We can add it to this if everybody thinks that that's needed, but we would have to, if you wanted to give the decision of that language over to board staff on what that would look like, that's absolutely something we can do. If you had a suggestion for it, we could input that here as well in the motion, or you guys can allow for that to just be kind of added to the website when we do update. Several options for you guys to consider.
Can we confirm that all the members have read this introduction?
This is Hillary. I read the introduction, and I just think that for now, I don't think we should get too granular, and I think that I would propose to accept the introduction as written.
Thank you. Do we have a second?
Rebecca DeSantis, I second.
Thank you. Mary Kay, we can open up to public comment.
All right, let's go to public comment on agenda item 8.
We will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Committee Chair Phillips, there are no public requests for comments. Would you like me to close this window?
Yes, please. Okay, let's move to a vote for agenda item 8. I'll start. Mary Kay Phillips. Yes, I accept.
Hillary Reyes, I accept.
Ruth Milky, I accept.
Jenna Shabatista, accept.
Misa Perrin Burdick, accept.
James Byrne, accept.
Rebecca DeSantis, accept.
Is that everyone?
Yes, it is.
Okay, all right. We move to approve it.
Yeah, the motion carries. We can move on to agenda item 9.0.
All right, agenda 9.0, discussion and possible action regarding admission privileges for certified nurse midwives at healthcare facilities. This agenda item was suggested through Ruth, and I'm totally on board with this. This is an issue that I've been working with at length, and I would love to create a subcommittee that addresses just this, so we can create maybe a, for lack of a better word, a toolkit or an algorithm or some sort of plan for midwives in the state of California that are trying to get admission privileges at their various medical centers.
So I'm going to jump in really quick and just kind of add some explanation and kind of read off the agenda item summary and then kind of have some further conversation around that.
Sure.
So section 1 of SB 1237 states that it's the intent of the legislator to ensure that preservation of nurse midwifery care in both the hospital and out of hospital settings by delineating the scope of practice for nurse midwives. There are some hospitals in California that are able to privilege nurse midwives by putting them underneath the categories such as provider or associate, medical staff, etc. But other hospitals are actually referring to Title 22 that discusses medical staff, and the delineation within medical staff does not include nurse midwives. And so this is really just the agenda item to open it up and have that discussion. I'm not 100% confident that a subcommittee could be met around this without specific guidance, because Title 22 does not fall under the BRN's jurisdiction. And if we are doing something and recommending something that is in opposition of what Title 22 is, that is has not been updated, then that's something we would have to take into consideration. So I'm happy to have the conversation as part of this agenda item to kind of share what you guys are coming up against, what various hospitals are doing to get around those issues, what are some of the barriers to this issue. And then with that information, I would like to have Reza and to kind of look at whether or not this is something that falls under the BRN's purview, or if this is something that would fall under CDPH, who is under the jurisdiction of Title 22. And again, we have Title 16 that we're under, but not Title 22. So just to kind of open that up for conversation, share some of the barriers that you guys are going up, share some of the wins that you guys have had out there with hearing that nurse midwives have had some privileges. And then based on that conversation, we would then be able to decide the path forward.
Thank you, Lori. I can open up the discussion unless someone else on the panel wants to jump in first.
I had a question. Can I pose a couple?
Sure.
So Lori, this is James. You've just opened up my awareness to a much greater degree of complexity for this than I had appreciated. I'm very familiar with the medical staff processes for privileges and all the components of that down to the granular level, but was not aware of how much variation may be allowed between various healthcare facilities. If I'm reading you right, this is actually a much bigger upstream problem that would need to be addressed before even starting to move toward getting people on staff.
I do believe so. Yes, I'm in agreement with you. And I, by looking at regulation and looking at statute all day long, I'm not sure how various hospitals are able to do this with the current definitions under Title 22.
So I can interject here because I've lived it and I've worked it for a couple of years now.
So having that information shared here on how various hospitals are doing it really does help us to kind of look at a path forward for that. So James, I appreciate your input. And yes, it is absolutely time for discussion, and it may be above what the BRN can do, but it may also be something that we can help to assist.
Okay, because again, I have about a 15+ year history of working with on the medical exec staff levels in these processes and writing bylaws. I didn't know there was a second universe out there covered by 22.
I agree with you, James, and I have sat on those committees and at length as well, primarily through the United States military. And it boils down to an interpretation of Title 22. So Title 22 states that the medical staff shall be comprised of MDs and DOs. Some medical facilities interpret that as limited to MDs and DOs and no others. Other medical facilities interpret that as not limited to. So as long as there are MDs and DOs on the medical staff, other disciplines can be invited to the medical staff as well. And this is how CMS, how Medicare also interprets it. And I have been in meetings and in touch with different representatives there, because the VA and the military system, the military hospitals within the state of California, give admission privileges to their midwives and welcome them on the medical staff. They do not limit medical staff privileges to MDs and DOs. So it's done and it's possible. It's an interpretation of Title 22. So some medical facilities prefer the interpretation that it's limited to, and some open it up as not limited to. So there's verbiage, semantics that need to be clarified. Now, it's possible that we need to reach out to the staff that manages Title 22 and ask for clarification. It's also possible that we reach out to these medical facilities and ask for specific, how do they intend to interpret this Title 22? But both ways are being practiced in the state of California. There are facilities that invite midwives onto their medical staff and give admission privileges, and there are facilities that deny that based on their interpretation of Title 22.
So I'm going to interject really quick to provide some additional information. When we reach out to talk, if the plan forward is to reach out and speak with somebody regarding Title 22, understand that that is a law and would have to go through the process of getting it changed, or they would have to release a statement that clarifies the interpretation of Title 22. Typically, that is done through a regulatory process, and that clarification goes through that manner. So it probably would not be immediate. The other thing that I wanted to provide clarification from, as Mary Kay was giving examples and using VA and military hospitals, the one thing for the public to know, as well as our advisory committee, is military facilities, including the VA and military hospitals, are not governed under California law. They are governed under the federal law. Therefore, they do not have to follow what is underneath CDPH, including Title 22. They also do not have to follow what is under the BRN, including licensure. So they can have employees in their hospital working as providers that do not have a license to work here within California because they are working within a federal building. So it may be that the VA and military hospitals provide the path for privileging for nurse midwives because they do not fall under the provisions outlined in Title 22 under the California Department of Public Health. So just to kind of provide that information that those federal entities are not required to follow California law, including the BRN's licensing process that requires all RNs to be licensed within the state of California to provide services here. That is not something that has to be followed, including the Title 22 staffing ratios, any of that kind of stuff within those federal facilities. It's not a requirement.
That's correct, Lori, and I totally agree with you. I will say, when we're talking about barriers for admission privileges, some of these medical facilities will tout or claim that a barrier is that they cannot get Medicare reimbursement if they give admission privileges, or for the work that midwives do, if patients are admitted solely under that midwife's license or name. And that's not true. The Medicare Medi-Cal system claims that as long as the provider with the admission privileges that's doing the work is a member of the medical staff, then there's no problem with reimbursement. But it's a catch-22 because those facilities then refer to Title 22 as a reason to not put the midwife on the medical staff. So that's where we are there.
Is there any information available regarding aligning opportunities for midwives to join specific med staffs? And by that, to help us identify where the most positive impact could be made most quickly, is there a sense of communities where there are CNMs ready, willing, and able to join med staffs independently, and med staffs that are smooth, or at least appear to be smooth with allowing that process, versus some which culturally they might want to allow that, but their bylaws are written as such that there's obstacles, so that we could try and target where the most favorable positive impact could be made over the next year or two.
This is Ruth, and this is an interesting conversation. My belief, and maybe those that are attending can correct this, is that for the most part, midwives in acute care settings have an access point. I mean, all the 4 or 5 hospitals I've been involved with was via med staff, and I was aware that the VA hospitals were more federal. So, I mean, are people aware that there are issues with non-VA hospitals or I mean, I guess I've never heard of midwives being credentialed by any other means except through medical staff, or not as physicians. Typically it's like an allied health person that doesn't get full medical consideration as far as their privilege packet. But I guess explain a little bit more for me. What hospitals have people identified that midwives are under Title 22?
Thanks, because that kind of goes along with one of my questions. I think understanding the landscape, Lori, like which hospitals have Title 22 structured bylaws, which do not. It sounds like there's a regulatory structure that has to be navigated before even going to the individual hospital or provider.
This is correct. I can speak for the Kaiser system, the Kaiser Permanente system, because it is the largest employer of midwives in the state of California. And Kaiser does not invite midwives to be members of the medical staff. Now, and so therefore at all Kaiser facilities, all admission orders written by midwives, and their privileges will identify the ability to admit patients, but that admission order has to be co-signed by a physician. And they even go as far as the history and physical that is written by the midwife at the admission process also has to be co-signed by a physician. And they are not budging from that position, and they use Title 22 as their rationale. Now, also know the hospital association designs medical staff guidelines, like bylaw examples for the state of California. And Kaiser follows that to a T, as I'm sure other medical facilities do. So it has been considered that our first approach should be through the hospital association regarding the recommendation of how these bylaws are written. So I don't know if that helps answer your question, James, but just as an example of a facility that uses Title 22 as a barrier, it's the entire Kaiser system. Now, some Kaisers in the state of in the state of Oregon and the state of Washington have created sort of a sub-medical staff where non-physicians are members. So it's not the same, and they still have to have co-signature on their admission orders, but they've kind of created this like subworld of a medical staff. So sometimes those midwives believe that they're members of the medical staff, but it is actually like a subset medical staff.
And so James, I'll jump in as well. So the hospitals that fall under Title 22 are all general acute care hospitals throughout the state of California. Each one, including Kaiser, falls under Title 22. The only ones that have a call out are the federal institutions that would follow federal law and not California law. Additionally, the reason that Oregon and Washington would have different privileging standards, then those would be because they fall under a different state law. And so just to put that out there, there are other hospitals that can use Title 22 as well. And so it is far reaching.
Can anyone give me or us an example of a medical facility in the state of California that gives admission privileges to midwives without co-signature from physicians, other than the VAs and the military facilities?
This is Jenna. I cannot, and maybe this is obvious and doesn't need to be said, but there's a whole host of really practical reasons why this is so important, including quality assessment and improvement, when we cannot even identify which patients were admitted by midwives versus their supervising physicians, because often the inability to be the technically admitting provider also means you can't be listed in multiple sections of the chart. So anyway, it's proved to be very challenging in lots of ways to even identify who's caring for the patient when they're not being admitted under the provider who's rendering care.
This is Misa Perrin-Burdick speaking, and at San Francisco General Hospital, I believe that our midwives have admitting privileges. I know that when I work with them, I am not named the admitting provider, and I don't co-sign any of their admission work documentation. But I would have to verify that there isn't some like standard operating procedure that they're operating under that really actually makes me the admitting physician, but my name does not show up anywhere in their charts when I'm the physician working with them.
That's helpful, Misa. I can reach out to San Francisco General Hospital because I would love to know the details behind that. Do you have a particular contact, or do you know anyone from medical staff? Or can you reach to me offline and give me any of that information?
Yeah, I'll generate an email right now.
Okay.
Lisa, I'm going to ask you to send that to Macaulay P. Sarins so that we do not have any possibility of violating Bagley-Keene.
Got it. So who do you want me to send it to?
Macaulay P. Sarins. She's the one that sends out all the emails. You can just reply back one of her emails with that information in there.
Great. Thank you so much.
Any other conversation or discussion regarding this issue or questions at this point?
This is Ruth again. So I just want to make sure I'm understanding, do we feel that we need to solve this question of how many midwives do not have access via medical staff first before we can move ahead in helping those hospitals that already have midwives as a part of their medical staff, but like this allied health? I mean, is there a reason we can't continue to help those hospitals? Help them create whatever it is, ultimately the toolkit or a way to make an access point for independent admission privileges? I mean, there are hospitals that are asking for it.
There are hospitals that are asking for it. I think more conversation has to happen. We have to make sure that we are not bumping up against Title 22 for another agency. That is something that I could reach out and try to find out, or anybody can absolutely do that. But I'm willing to take that if that is the path that you guys would like me to do. It comes down to jurisdiction. Our board cannot create law or update a regulation that has to follow law if it directly opposes another California state law. They have to be in alignment. So they're when regulatory processes like the previous agenda item was voted on to proceed, that goes through a review that happens at the BRN level. It also happens at the DCA level, and then it goes up to agency, and then it goes to the Office of Administrative Law, so that all of that review process occurs to make sure that there's not overlaps, to make sure that there's not something that it's going to affect. When it is something that is occurs within legislation versus in regulation, that happens at the legislative level. You'll see there are several bills going through right now that are not specifically around nurse midwife care, but around nurse practitioner care. And there was AB 852, there was SB 1375, sorry. There was now our BRN sunset bill, and all of them had various updates to nurse practitioner care. Then, so they pulled all of the nurse practitioner stuff out of 852 so that it didn't conflict. And the legislative staff, or the sunset bill for BRN, is working closely with the legislative staff from Tony Adkins' office for the bill, and they're making sure that updates to those sections do not cross. And that is a requirement that has to happen so that you don't have multiple laws contradicting other laws. And so that is definitely something we have to do in order to kind of reach out. So there was nothing specifically included in SB in your updated bill that just came into law that we've been implementing that said CNMs are allowed to be a part of med staff, or CNMs can have admission privileges. If that was added in to this bill and became part of our BPC code, that would allow for us to promulgate regulations if needed, or refer stakeholders back to the BPC code saying it is law. This can be done. It makes for a very cut and dry, very clear process when it is something that is signed into law through the legislative process. It's a little bit more muddled as you go through the regulatory process, but it does still have to refer back to the code, or the law that was passed with the passing of the signing of a bill. And so with this process, the first step would be is anything in this toolkit that you are wanting to put forward, does it oppose what is in Title 22? Or does it oppose anything that's within the Health and Safety Code? Does it oppose anything that is in California law that would need to be updated? If on that review process, it is found that there is conflicting law, then the path forward would not be a toolkit. The path forward would be that these organizations that advocate for your various professions would then reach out to a bill writer and sponsor legislation for next year to include an update to our business profession code or to Title 22 to have this changed so that those admission privileges can be granted. If it is found that there is support within the current law and that it just needs to have an updated interpretation, then that is something that the organization that falls under that jurisdiction would have to make that movement forward and send that out. It could be as simple as sending out an all facility letter that comes out through CDPH that provides that clarification. It may not be that simple though. So to move forward on creating a toolkit without knowing the legal responsibilities first would not be advisable in this situation. I do think that there is more research that needs to be done so that we can establish a legal path forward, so that this is something that the stakeholders and the public and the midwives have something to fall back on. As you guys are completely aware within your practice, it's easier to go to the board that has the jurisdiction over you, or the department that has the jurisdiction over you, and refer them back to the law that says, hey, no, I've got law that backs me up on this. It says this, this, and this. Then it's not as easy to say, well, that is what our practice is. And it is because, this is the way it's been passed down from generation to generation, or this is how this group interprets it versus the next group versus even the next group. And so you want to create that continuity, and you want to make sure that you're not overlapping in any other state laws that may govern this at a higher level than what our Nurse Practice Act does.
Thank you, Lori. There is conversation among the authors of SB 1237 about follow-up or readdressing the law with this inclusion. There's also conversation about clarifying Title 22. The last thing we want to do is clarify it to the extent that it becomes detrimental to facilities who've interpreted it as not limited to MDs and DOs, but that may happen. And so there's a couple of routes to legislatively that are in conversation now. And I can update the committee if I find out more, or I would recommend to committee members who have an interest that they get in touch with CNMA and get involved with the political action committee in that group. So I agree with you. We can't really create a toolkit until we have a pathway. So, anyone else?
Well, I agree with that. So what are our next steps? How do we get a pathway? I mean, is it having Lori or a designated person go to what would be CDPH or Title 22 and
if
ask for
Lori can
interpretation?
get some clarification on Title 22, I think that would be very helpful. Or at least a contact regarding like the staff who are tied to Title 22.
Yeah, I will reach out and get a contact for you, and then with the information that was shared with Macaulay, we'll put that information together and share it out to you, Mary Kay, with that information. And then as chair, you can decide the path forward with that. It does sound like there already is a path forward, and that's news that Mary Kay just shared, that there looks like there may be some sort of a cleanup bill working with the previous author's office, so that there could be something that is in statute that specifically states this. And that kind of looks like that's the path forward. So that to me sounds like next steps, and that is just knowing that a cleanup bill is out there. As a advisory committee, we cannot make a vote that we move forward with the cleanup bill or anything like that. That's not something that the BRN can do. That is handled through the various organizations that support the profession. And but what I can do is reach out to CDPH and get you guys a contact person on who to speak to regarding that, if that is the request that is coming from this committee.
I have a comment, or a question. Would a cleanup bill supersede Title 22, or is the issue still interpretation of Title 22.
So within a cleanup bill, it would not necessarily supersede, but what it would do is it's going through the process is clean up any code that would need to be adjusted if this provision is put into place. And so there are several times when, say that you're looking at updating prescriptive authority from the BRN standpoint with midwives and nurse practitioners, you would also have to go in that current bill and touch on various other code sections with the law to update those around pharmacy that fall under pharmacy would have to be updated, et cetera. So that is the process that would take place during that legislative session when the bill writer has conversations with the various stakeholders, including the boards, bureaus, or departments that the bill may affect. And then working with the members of those organizations, they would provide feedback. Many times in this position, I've had to provide implementation feedback on bills that are not necessarily a direct impact to the BRN, but that may, bump up against it. And I would have to provide input that would say, if that goes into place, I would have to address this, and this of my law to allow that to occur, and not my law, but the BRN law, that the Nurse Practice Act, or nope, that would be perfectly fine. There's no direct impact here. Just great to have it as information only. And so that is worked out within that legislative session with various stakeholder meetings.
Regarding a path forward, I do think it would be helpful, Ruth, if you and any other midwife out there that is seeking admission privileges at their various facilities to continue to pursue the effort, knowing these barriers, but just to get feedback in their facility, what are the specific barriers at their facility, because there may be more identified than I'm aware of. Like right now, I'm very aware of our Title 22 issue, but if there are other barriers being thrown at midwives in various facilities that prevent them from getting admission privileges, or if luck has it and someone gets admission privileges, I would love to have feedback regarding how that happened, or the additional barriers, so that we're not blind, like we don't go down one path and then we're blindsided by another. Does that make sense?
It does. And Mary Kay, thanks. It's obvious that you have a real impressive depth of understanding of the regulatory side and the system level. I thought one of the issues would be something much simpler, such as medical staffs typically have medical malpractice minimum amounts required for all providers on admitting staff, regardless whether an ENT physician or an OB-GYN physician. And I had concerns that the exact same numbers would be applied for midwives, also applying for med staff. But in light of some of these regulatory things, that concern all of a sudden takes a real back burner.
Yes, and there will be other limitations to medical staff membership that midwives may not be aware of. Many facilities, the members of the medical staff pay into membership. There's a cost associated that's repeated like every 2 or 5 years or what have you. So it's not always just a granted medical staff membership. Often there's, like you said, a regulation regarding insurance, fees. It really depends on the specific medical facility, but it's not just as cut and dry as like, oh yes, you can be a member and now you have admission privileges. I understand that. So do we need to open up this agenda item for public comment?
Yeah, there could be no motion made. I did just reach out to CDPH and ask for contact information, so that has been completed. And you can decide not to make a motion on this agenda item, and you can open it up to public comment now. I did want to let you guys know that it is 11 o'clock. Excuse me, our meeting is scheduled to end. So we would have to postpone agenda item 10.0 unless you wanted to give just a few minutes, and I can give a quick update, and we would leave that as information only. But yes, we can go out to public comment now with no motion.
Let's go to public comment, and then we'll address agenda item 10 as soon as we're back.
We will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Committee Chair Phillips, there are no public requests for comments. Would you like me to close this window? Sorry.
Yes, please.
And there is no vote needed because there was no motion, and we could move to 10.0, and I can give a quick update if that suffices.
Yes, I think that's a great idea. Agenda item 10, information only, presentation on enhancements and efficiencies made in the licensing program. Lori?
Thank you. So it has been brought to our attention, and this is not something new, unfortunately, that nurse midwives, nurse practitioners, clinical nurse specialists, nurse anesthetists, and even the RNs that are seeking license run into barriers to that, including lengthy delays when working with the BRN. And so our DCA, our licensing staff, our entire BRN team has really been focused on what we can do to improve every aspect of the licensing unit, including making it much more efficient and faster for people to receive their license. So there have been several licensing updates that have gone forward. The first was to address the pre-licensure nursing programs, because that is the greatest number of license requests by examination in the state of California. We did create an automated service that allows for the nursing education consultants to review and approve all of the curriculum prior to graduation, so that the graduate from that institution does not need to submit a specific transcript. We get an attestation from the dean or director that is BRN approved, stating that these students, and it's a listing of students that have applied under their school code, can be issued an authorization to test, and they give us their graduation date and the degree obtained. Those deans and directors do wait for the degree to be conferred by their institution, typically before moving forward with that process. And that has been in place now for coming up to a year. And that is really expedited processes. The good thing is that brought about those changes, and we decided to include the advanced practice registered nursing programs that have BRN approval within California. That is the nurse practitioner programs, as well as the nurse midwife programs that have sought voluntary BRN approval. Please understand that the nurse midwife education programs residing in California right now are not required to have BRN approval, but each one of them have opted to receive this. That way their graduates can be licensed through the Method 1, which is coming from a California approved BRN program. So that automated system that was there for our new grads from the pre-licensure program has been expanded. Now, all nurse midwife programs and all nurse practitioner programs that have been BRN approved by having an NEC review their curriculum up front and approve the program director and such can now input that information directly through a sign-in system that we have available to them at our BRN. They no longer have to submit transcripts. That will then allow for that process to move quickly through. This has been expanded to also provide the furnishing number within that same system. So the CNM program director accesses the system that gives a querying of names that have applied. They then say, yes, they've completed the nurse midwife program, and yes, they've completed the furnishing requirements. That is submitted without any additional documentation required, and that can then license that person within days. And so that is a very great update, and that has just been rolled out in the last month or so. So we're still working out some of the kinks with the programs, providing training to the program directors to be able to do this, but that is a wonderful step forward. However, the endorsement part, so the ones that are coming from out of state into California that have already worked as a nurse midwife or a nurse practitioner, et cetera, still needs to be addressed. That is still a process that requires a lot of additional steps and a lot of additional documentation. One of the things that is moving forward is within our sunset bill, and that is to have an option to combine the applications. Doing one midwife application that would then allow them to get a furnishing number with that application. And that would be the same process with the nurse practitioner. That has been proposed in the bill. And if it goes through for signature and implementation, that will be something that our board will do. A timeline on that to let you guys know is there's not an urgency clause. So if the governor signs it in September, we will then start to implement that. And the implementation typically on that is for January 1. So we will work hard to make that happen. It does require some licensing updates, so I can't guarantee that it will be effective immediately January 1, but we will make every effort to get that through, just pending the update to the application system, Breeze, essentially. So a lot of stuff has been happening to move this along, make this much more efficient. Some key takeaways for the endorsement applicant is that they need to come in through a national certification. That is the method 2 process for getting approved as a nurse midwife in California. The nurse midwife can only be approved after the RN license is approved. So in the off chance that the person's pre-licensure nursing program did not have the same educational standards that is required within California, they may not be able to be licensed as an RN. So that is absolutely something that applicants should take a look at. That is under 1426 of our California Code of Regulation that talks about the education requirements to ensure that they can be initially licensed as an RN before being licensed as a nurse midwife. Within the nurse midwifery application, that national certification has to be a primary source document. It cannot be delivered by the applicant. It needs to be delivered from the national certifying agency. So when the applicant requests the national certification, they need to request it to be sent directly to the BRN. That is the same process that is done with transcripts. When you submit your education history, it cannot come from the applicant. It has to come from the academic institution or through an e-transcript service such as Parchment. Then finally, if you are applying for your furnishing license, you have to show that the advanced pharmacology course was taken and completed successfully within the last 5 years. If your advanced pharmacology course was taken prior to the last 5 years, you do have to show that you have been employed within a state that allows for furnishing, and that you do have that competency. And there are various ways that that can be communicated to our board staff, and they send out a letter letting you guys know those ways. Those are the kind of cumbersome process for endorsement applicants that is different than our California grads. But we did make huge strides this year to improve the California grad process for our advanced practice RNs, as well as our pre-licensure RNs who are graduating from California approved schools. Our next step is to really see what we can do to address the endorsement process but by providing some very clear guidance as to what is needed on the initial application, we're hoping that that will go farther so that people will submit an application that is full. That means that they have the application for the midwife filled out correctly, fee paid, application for the furnishing license filled out correctly, fee paid, transcripts coming from their pre-licensure school for their RN, an application for their RN, transcripts coming from their nurse-midwifery program that they took out of state, a national certification coming as a primary source data, and information around their furnishing license criteria. With all of those are received, we are currently required to review these applications within the 30 days of receiving them. Applications that have all of these submitted at that time will be reviewed and approved if everything meets the standards within that 30-day time period. If there are missing items, the applicant will receive a deficiency letter letting them know what specific areas they continue to show as deficient. Additionally, it is on our website under the application status and details page. And you can find out specifically what you're deficient in, and then you would have to go through the process of getting that resubmitted. That would then have to go through that licensing process a second time so that they can review the new documentation turned in and add that towards the itemized checklist that is required in order to clear your license to have it active in California. If there are multiple items that are outstanding, each time an item is received, it does have to go through that review process until everything is cleared. And that can be lengthy depending on the response timeline of getting those documents, of procuring them, of asking for primary source data, having them sent to the board, etc. And then allowing time for board staff to review and check to make sure you meet all the statutes and regulations, and then issue a license. Was there any questions?
Gratitude for a really good summary. Thank you.
Thank you. It is quite cumbersome on that endorsement side, and that is our goal in the next year or so to really get that cleaned up. But we made huge strides this year to address the California grads. So thank you for that.
The processes of primary source verification and the rest are pretty much the same for both the BRN and the medical board. Has there been other issues that have resulted in longer time processing? So it's not just the requirements that society should have of each individual being fully vetted, but have you had manpower issues or COVID delays in staffing? Anything else that we're contributing to the CNM?
Not necessarily. Our team went to a kind of primary telework environment back in May of 2020. And they provided support through that. They can come into the office, really just always looking and refining that process to allow for it to be as accessible and easy as possible. There have been times where we heard that the connection is slower. And so we're working on that. Sometimes equipment is not as quick as we would like it to be. So we've worked on that. We just procured 200 laptops that will be going out to various staff within BRN. that will allow them to VPN directly in versus using a cloud desktop. That should help speed up the process. But our licensing staff are an amazing team. When anything starts to fall behind, that group reevaluates the processes and will pull people off of other tasks to assist the area that's falling behind. What really delays a process that is outside of our control would be if the pre-licensure nursing education doesn't meet our standards. We do have Excelsior College located in New York that we actually have a legal statement that says we cannot receive students that have been trained through that organization. So no matter your additional training after that, if you've got a PhD, a nurse midwife, et cetera, we can't accept you because in order to be licensed as an advanced practice RN in California, you have to initially be licensed as an RN. And since we cannot do that, that subset of individuals cannot be licensed in California. If you've gone to a school that didn't require like a microbiology or anatomy and physiology with lab, that is a requirement of our pre-licensure program, they would have to redo a micro or an A&P course with a laboratory component, then get their RN license, then get their APRN license. So it's quite cumbersome, but those are some difficulties that people run into when they try to endorse into California. The good thing is that is on our board's radar, and we have looked at adding a regulatory code 1410.5 to provide an alternate pathway for people that don't have micro or anatomy with lab into California, and that's going through the process. The board did vote on some language. There is some revisions that were suggested by stakeholders, and that will go back in front of our board to move that process forward. The other items would be people that have any enforcement or background issues. If they have their license disciplined in another state, that does require a review process. And that does delay that initial licensure by a bit as well. So those are some of the things that happen, but truly one of the big things that we see is missing documentation. We're working really hard to kind of clean up that process within the BRN, but we are responsible for some of that. And the kind of part that we can't really address is with our Department of Justice. They require live scan vendors to be located within California in order to do a live scan fingerprint. And so any out-of-state applicant must travel into California to do their fingerprints via the live scan process to expedite that fingerprinting process. If they are out of state and they choose not to come into California to do a live scan from a vendor that is located in California, the Department of Justice requires hard card or rolled fingerprints to be done. And that on the DOJ website says that it can take up to 13 weeks for that process to be completed through them before it can be cleared by us. We cannot issue a license in California without having the background information. And so that sometimes is a delay.
Lori, do you want to address the future of the furnishing license in this information section, or is that something for another time?
Yeah, I did cover that. That is information that is in the sunset bill. And if it is passed within the sunset bill, it will be a singular application for midwives that meet those requirements. And so there is an education requirement around there, so we do need to ensure that that is standard. I can tell you with nurse practitioners, I believe the master's degree and higher requirement came as of 2008. I believe nurse midwives, that was 2010. And so those would be the people that would be able to combine those applications because the education is there. So that would be kind of the process that would go through. And then the intent is that when that information is given, that both licenses are issued at the same time versus having any type of a delay or not having information transfer. So that we're working on that secondary half of doing the furnishing license after the issuing of the nurse midwife license on an automated system that's already in process and kind of working on a build for that and an implementation of that. But if the sunset bill language goes through, it will be a singular application with a singular fee.
Thank you.
Welcome. And if there's no further questions, we can open this up to public comment. And then when that is complete, we can adjourn the meeting.
It sounds like no further questions, so let's go to public comment.
We will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Committee Chair Phillips, there are no public requests for comments. Would you like me to close this window?
Yes, please. All right. I guess we've come to the point where we can adjourn the meeting.
Thank you guys so much.
Great meeting.
Thank you. Meeting is
Thank you,
adjourned.
everybody.
Thank you.
Thank you
Thank you,
all.
everyone.
Stay safe.
Thank you.